Led by learned advocate general, my lord.
The writ petition may be disposed of, your lordship, and I'll file the certified copy, your lordship, because it would not be.
Learned advocate general, my lord, has requested my learned friend for taking for seeking accommodation. When my learned friend is said, Lord, that matter may be taken up after 31st. We have no objection, Lord, because there's no scope of any interim order or because the day for which they have already prayed for, that has been over. Let's Lordship kindly fix it after 31st, subject to Lordship's convenient.
Yes, my lord.
He has requested.
Advocate general request me this request. Yes, my lord, that any fixed date, my lord, because of that very objectionable observation, then that too equality. I am praying before this court of
My lord has seen
equal treatment for the every political party.
If he is a member of legislative assembly, he is accountable to the people who elected him.
mine.
If suppose he does all this mischief and he goes behind bars, who will protect the interest of people who voted for him?
My lord, kindly then my lord, kindly see the bail order which is annexed to my appel. I in non.
Maybe some false cases will be
Yes, my
registered, politicians, etc. But here, riotous behavior.
Not at all, my lord. It's depressed of respect to the. That's the kind of page number 125.
This heroism and all in
Yes.
movies, it will be all right.
Yes.
But when it comes to real public life,
But real,
My lord has seen.
my lord, in real public life, what happened in our state, my lord, kindly see, my lord, the scenario, the exact scenario. My lord will get the glimpses of that scenario from the page number 125. My lord, kindly turn for once, just for once. This is a bail order, my lord, page number 125. Relevant page number 126. I just, which my learned friend, my lord, wants to refer that violence. Kindly take page number 126. At this stage, the state is unable to demonstrate that the petitioner indulged. The petitioner means
Prima facie.
indulged in inciting the crowd to assault the petitioner or to assault the police or to indulge in destruction of public property. And not only that, my lord, and that too, petitioner is in custody for 40 days. Police
Yes.
filed charge sheet.
Yes.
After filing the charge
That's right.
sheet,
That
the
was the
state
consideration.
unable to demonstrate any involvement,
But
my
that
lord.
is the
And this is the observation of the coordinate bench, my lord.
And a single judge.
So, my lord,
that is on
No, learned single judge, but
that is on the criminal jurisprudence.
yes, my lord.
yes.
Because a person cannot be detained, his rights
Yes.
cannot
After
be
the charge.
please, sir. His rights cannot be curtailed, etc. But when it comes to a demonstration or a celebration which will affect not your party or your rival party, but the common man.
Yes,
Yes.
My lord, kindly with the request of
No, that's where the writ court has to examine the aspect in that perspective.
yes, my lord. I am bow down.
Sir, you are on a bail. You have not been acquitted. Charge has not been quashed.
My lord.
He is arrayed as an accused in a criminal case. Whether it's a false case, it's been foisted on the appellant, political rivalry, etc., to be decided elsewhere. But when it comes to some sort of a procession,
Then equal.
then we need to look into antecedents.
My lord.
My lord, then, my lord, equal treatment for everyone. That's my point, my lord. Equal treatment for everyone. My lord, kindly I give an example, my lord. Every political party, my lord, I also annex
Oh,
some of the political leader who are in ruling dispensation, they are minister of the state.
And they are
How many
violating
cases are
public property.
against them,
Public
which is
property.
evident from their affidavit, vote
Public
affidavit. Now, my lord, the thing is that, my lord, if that's so,
Affidavit is uploaded.
yes, it is uploaded. I annex with my appeal. If I don't want to make any submission in
My lord has
presence of
seen
the Advocate
the
General. I want
videographs
equal treatment from the
on
state for every
earlier
political
occasion.
party, for every political
My
leader.
lord has been.
I want so.
No.
That's why, my lord, this
Earlier occasion, this
and the
appeal,
guideline for the
My lord
holding
has
the
seen
political rally and
activities of
it is
the
very much relevant. My lord,
What
remember
is-
the last occasion, my lord, when I placed the case. Sorry, my lord.
In page 123, internal page 11 of the single bench order,
Yes,
the names of the following persons as forwarded straight are quoted below.
that is 2023.
They have supplied.
My lord, no, that is supplied by the state.
Yes. Yes, supplied by us. But they have supplied the
After
case numbers.
recording those 20 names, a list of 10 organizers would be handed over to the police in advance so that in case of any crisis,
Yes,
both parties may communicate with themselves and dilute the situation. There is no adverse comment.
No, that is not. But the non-presence, kindly, why I before this court? Because of that, this incident in respect of 2023. Thereafter, by the last year, in the year 2024, by referring my lord's order that says my lord giving a prohibition. Because of that, my lord, kindly see the whole order. Why this order is passed? Because of the reference of the last year order, my lord's order. My lord, kindly see, I will place, if once my lord, I place the whole order.
No.
The tenets of the order is that.
Sir, please, sir, this is not an adverse observation. All that they wanted is your organization should give the names of 10 people. In the event there is a problem, we will call them, you dilute the situation. What is the
No, my lord. Kindly see the page number 11. The name of the following person will not be present.
You celebrate your foundation day in your own house.
Yes,
Nobody will ask. Once you come into the public street, you are bound by reasonable restriction.
My lord, that reasonable restriction, they will not non-presence. My lord, kindly see, my lord will not. I am not about these 10%. I am about 20%. My lord, kindly see, my lord, the page number 10. It starts from page number 10.
Sir, the learned judge has not made any adverse observation against these 20%.
My lord, not only my lord, referring why I came before this court, but I may place the case. Otherwise, my lord, the case is that, my lord, in the year 2023, there was a incident happened, and that incident there is no way connected. This political party is a political party, and the supreme leader of this political party no way connected with that incident.
The learned judge has not said he is connected.
I place the case. Kindly give me some time. Otherwise, it will go the wrong message. And
No.
I place the case. If my lord wants, I place the case. What happened, in the year 2023, my lord? It's happened. Thereafter, my lord, in the year 2024, that means last year, my lord, they deny our Foundation Day program, my lord, in respect of 4 incidents. What incident? One is on the grounds of marathon, another incident is the ground of vintage car rally, and another incident, another party's rally. That's why they says we will not give you the permission to hold the rally before the Victoria House. Thereafter, my lord, we came before the court, my lord. And the single bench, my lord, allow us. The state preferred an appeal. And basis of that appeal, my lord passed in the last year. That means the last year order. And my lord order is annexed by referring my lord's order, just one line. That was just one line. My lord, kindly see my lord's order. That reference, just there was a mentioning that the last year happened such and such case. And that this year, my lord, by using that line, they says, see, the last year division bench passed this order, so they are holding this rally. So that incident is still continuing, and kindly on the observe in the context of violence.
Management is misleading the court. It is learned single judge has requested him to go to the division bench.
Kindly see, my lord, 113, page number 113, my lord, that is mentioned. My lord, page number 114 onwards.
Yes, we saw that.
Yes, my lord, kindly. Without going into the details of the
we will clarify, there is nothing against your party. No adverse observations have been.
That observation is enough. No.
The order.
Yes, my lord says that it will not carry upon the next year. That will be enough for me.
This
Would your lordship pass the order, or my lord, in presence of the learned?
Sir, please hear.
My lord.
This intra-court appeal by the writ petitioners is directed against the order dated 20th January 2025 in WPA 1390/2025. Firstly, we need to point out that the appeal itself has become infructuous on account of the fact that the Foundation Day, which was proposed to be celebrated by the first appellant political party, is already over, as it was to be held on 21st of January 2025. The learned advocate appearing for the appellant would vehemently contend that certain observations made by the learned single bench would impinge upon the rights of the political party and its leaders, of whom one is a sitting member of the Legislative Assembly, and this would be cited as a precedence in the years to come, whenever the political party proposes to celebrate the foundation day. We have carefully gone through the impugned order and we find the learned single bench, after taking note of the order passed by the Joint Commissioner of Police dated January 14, 2025, made an observation that without going into the details of the contentions advanced in the writ petition, the court noted the order passed in an earlier writ petition in WPA 1196 of 2024 and the appeal preferred by the state against the said decision in MAT 148 of 2024, quoted paragraphs 5, 6, 7, 8 of the division bench judgment, took note of the submissions of the learned advocate for the appellant writ petitioner that the state is set on the same grounds is refusing permission for the program to be conducted in January 2025, and also noted the other submissions made by the learned advocate for the appellant writ petitioner. Thereafter, the learned single bench has noted the submissions of the learned advocate general appearing for the state, and the decision relied on by the learned advocate, the decision of the Honorable Supreme Court relied on by the learned advocate general in the case of Amit Saini versus Shaheen Bagh, Indri versus Commissioner of Police and others, 2020 10 SEC 439, quoted paragraph 16 and 17 of the judgment of the this Honorable Supreme Court. And also made an observation that the respondent police is silent in respect of the conduct of the writ petitioners and its members in the year 2024, and observed that it can be presumed that there were no complaints against the writ petitioners and / or its members and or / or its sympathizers and / or office bearers. Thereafter, the court made the following observation. At page 121, paragraph starting, having, and ending with reasonable restrictions. After recording the above, the learned single bench took note of the date and time when the writ petition was being considered and granted liberty to the writ petitioners for an assembly of 3,000 persons to be held at a particular location from 12 p.m. to 4:30 p.m. on 21/1/2025, who are to follow the route prescribed by the police authorities. In addition thereto, certain conditions were imposed. Thereafter, the learned single bench has noted the criminal cases which were registered and observed that the persons who are implicated in the criminal case will not be allowed to participate physically in the meeting. The learned advocate for the appellant would submit that names of 20 persons were given by the state, which has been referred to by the learned single bench. It is full stop. It is no doubt true that in page 11 of the impugned order, the names of the 20 persons which was furnished by the state was quoted. However, there is no other observations qua those 20 persons. In the next paragraph, the learned single bench has observed that a list of 10 organizers would be handed over to the police in advance so that in case of any crisis, both the parties may communicate with themselves to dilute the situation. Appropriate directions was issued to the police for deploying adequate force. The first appellant political party was directed to ensure that members, supporters, attending participants to conduct themselves in such manner as they are responsible citizens and answerable to the citizens of state for their acts and actions. Thus, we find there is no adverse observation made against the leader of the political party or any of those persons. And in our view, the restrictions imposed are reasonable restrictions, since no person has got a fundamental right to protest in a manner as they wish to do. And this is not the scope and ambit of Article 19 of the Constitution. The first appellant political party should bear in mind that the paramount interest of the general public is, the interest of the general public is paramount compared to the interest of the political party which wanted to celebrate the foundation day. Thus, we find there is nothing adverse for the appellant to challenge the impugned order, particularly when the prayer itself has become infructuous.
This prohibitory order, my lord, kindly see the page number 11. Because of that, due to this prohibitory order, my lord,
Next year we will ban. Next year we will ban it.
My lord, kindly
File appeal to Supreme Court. Yes, sir. Kindly speak.
my lord, kindly this is done next year, because year to year it is for every political party, my lord. If that for only one single political party, my lord. My lord, if that is so for one single political party.
Next year I won't be here.
But order will be there.
My lord, order will be there. They will use it every year for the single political party. My lord, kindly see, my lord, it is used for the one single political party, my lord. My lord, it is they treated the state ought to be.
In another matter, we will.
My lord, if that is so, my lord, it is a prohibited order for a single political party,
Yes,
my
sir.
lord.
Yes, sir. We heard, sir.
My lord, my lord, otherwise, my lord, it will be a sufferance for a political party each year to year, my lord.
In fact, we have made better observations than what was there.